Hi, and welcome to Collaboration is Key, working with victim service professionals. This is part of AEquitas's Foundations of Sexual Violence Prosecutions series. And really excited today because part of AEquitas's mission really is to be innovative, informed, and hopefully very practical so that we can give you skills and strategies that you can take back to your work right away and start implementing them. We do that by having resources and trainings available to you, a lot of them free and on our website, but we also offer 24/7 consultations. So if you have case-specific questions or you want to discuss a particular strategy or maybe even improve a collaborative response, we can help you with that. We also very involved with various federally funded partnerships and initiatives like the Sexual Assault Kit Initiative or the Saki Initiative, and much more. So please check us out online, follow us on social media, and so that you hear the latest and greatest that we're providing to you, whether that be a resource or a training opportunity. This particular series is funded thanks to the generosity of the Office on Violence Against Women. That's part of the U.S. Department of Justice. And our conversation today may not necessarily reflect their views, but we do thank them for their support. We also are constantly using emerging research and resources and promising practices, and we do that under the Fair Use Doctrine. So without further ado, I'm Jane Anderson. I'm an attorney advisor with AEquitas, and I'm really happy today to be able to chat with my colleague, Jonathan Kurland, who comes to us from Berks County, Pennsylvania, and a really in-depth experience having prosecuted crimes of sexual violence and other related crimes. So Jonathan, I don't know if you want to introduce yourself a little bit more.
Sure, Jane, it's great to be participating in these conversations with you again, and thank you for the introduction. Hi, everybody. My name's John Kurland. I'm an attorney advisor with AEquitas. I've been an attorney advisor with AEquitas for 5 years last month, August 2022, depending when you're viewing this. And prior to that, I was a career prosecutor. I worked for 16, 17 years in Berks County, Pennsylvania, where I focused on crimes of sexual violence, child abuse, child molestation, intimate partner violence, homicides, things of that nature. And it was a wonderful career and something I still strongly identify myself as. I think of myself as a prosecutor. But had an opportunity to join AEquitas and work with great people like Jane Anderson. So it was a opportunity not to be neglected.
Well, we thank you that you bring all that experience and expertise with you, because today's conversation on working with victim service providers, it just, it struck me as you talked about the kinds of cases that you worked. Those are exactly the kinds of cases where this is so incredibly important. So the conversation today is going to focus on how to enhance our ability to collaborate with victim service professionals. And hopefully we can focus on what that means from like a systematic response, but also in less formal ways and things that line prosecutors can do just to help their own practice. And one of the purposes of this is to think about how prosecutors are here to serve survivors. And one of the ways that we do that is make those connections and making sure that the survivors and victims we're working with have access to appropriate victim services. And what is our role and how does collaboration help us do that more meaningfully? And then ethically protecting the victim privacy and what that means in the context of maybe a community-based advocacy program that we'd be working with. So Jonathan, we say victim-centered approach. We say that all the time. I was hoping you could explain what that means to you in your practice as a prosecutor.
Sure, and especially in the context of working with other disciplines and other agencies and providers. Usually, I think sort of the stereotypical view of a prosecutor is the flip side or the counterpart to victim-centered approach, which is offender focused. Like, I'm just here to get the bad guy. How can I get the bad guy? And in its most reductive terms, you just look at victims as talking exhibits. The thing is, though, is what practice really helps us understand and reveal is besides sort of not being a very professionally or even, I don't want to say ethical, but the right way to approach things, it's also not very productive, because by not having a victim-centered approach, by not looking for ways we can support the victim, where we can help promote the victim's healing, where we look at, when we don't look at the victim as a whole person, our cases usually fall apart too. And so the victim-centered approach is really the idea that the prosecutor is not just asking themselves what's best for the case, but what's best for the victim and how can I help the victim? And by doing that, you're also going to, more often than not, also do what's best for the case, especially when you look at what's best for the case from a more holistic perspective. Now, in terms of a multidisciplinary approach and working with other providers, this is a way to do that. Prosecutors, although we often sometimes feel like jacks of all trades and like we have to do everything, by working with other agencies, other disciplines that are there to help with the victim, we can have sort of a force multiplier. And that's the idea of a multidisciplinary approach. So we look at other people that the agencies, disciplines the victim is going to be interacting with, and rather than shuttling the victim to each of those different disciplines, is that we all collaborate together and focus on the victim together, each lending the benefit of our expertise and not siloing ourselves from one another, but using all our different expertise and disciplines to have a victim-centered approach, to make things as better for we can, or help to at least minimize re-traumatization as best we can.
So I kind of use the term victim service professional as an umbrella term, but there's actually lots of things that fall under that umbrella. It's not just one monolithic kind of victim services. And so I thought maybe we could talk about what the different roles could look like, and maybe even just like sometimes they're named different things, and how they work together, and why it's important that we as prosecutors kind of understand those different roles and responsibilities.
Yeah, I agree. And victim service professionals, I think that's the biggest umbrella term we can use for this. And it's going to be further complicated by, depending what jurisdiction you're from, you might have other terms you're using that are beyond this list we have here. By no means is this list intended to be exhaustive of every kind of person. But when we're talking about victim service professionals in the broadest sense, it's who are people working with the victim when a victim has a case, when a victim's been victimized. I shouldn't even really say a case, because victim service professionals could be working with the victim even when they never report to law enforcement, even if there's not an active prosecution or an active investigation. So I talk about all the people who interact with the victim when there's a case, which is usually when it comes on prosecutors' radar. But it can be broader than that too, because there's lots of victims who, for lots of reasons, aren't able to go to that criminal justice door. And we have to respect those reasons and try to empathize and understand those reasons too. But think of ourselves from, look at what happens when a victim is victimized, and who are they going to be encountering as a result of that victimization? Are they going to be talking to lawyers? If this is an intimate partner sexual assault or something of that nature, where they're separating from their partner, or there's going to be some sort of separation like that, are there going to be lawyers who are going to be involved with a family court or civil court system? Maybe if it's not even intimate partner sexual assault, maybe it's just some sort of pre-existing relationship, or maybe the victim is looking to pursue civil remedies, separation orders, or protection orders, or things of that nature. Maybe they're having to defend themselves against defamation or some sort of slander lawsuit that's used offensively as a victim. There's going to be lawyers involved with that. And we shouldn't look at them as adversaries or complications. We should look at them as other resources that are going to be there to support the victim that may not be understanding what we as prosecutors are trying to do. Medical professionals, of course, maybe there was emergent medical care that was provided as a result of the assault. Maybe there's long-term or ongoing medical care. Victims obviously going to have privacy expectations and things that we should respect in relation to medical care they receive. But nevertheless, where there is an overlap, how can we work with these medical professionals to best service the victim. And when there is a case, look to move the case forward. And then we have a lot of different victim witness counselors, service coordinators, advocates, or specialists. These can come in a variety of things. And really what we're going to talk about most later, whoa, what kind of phrasing is that? What we're going to talk about later is these folks that are working and that are designed to work directly with victims. Are they falling under a community service umbrella? In other words, some sort of agency or entity outside of someone who's government funded? Or are they going to be system-based, like someone connected with an existing government agency, whether it's maybe our victim witness coordinators that we might have in a prosecutor's office, maybe victim support specialists in a law enforcement agency, or any variety thereof. And like I said, you can't be exhaustive on this, and we certainly wouldn't even attempt to.
Yeah, because I remember as I started my career, we had victim witness counselors, that were in my office at the prosecutor's office, and they were assigned to the case, and they did a lot of work with me, connecting me to victims, helping me get in touch. But I don't think I ever really understood what their role was and maybe what it wasn't. And so that's kind of the next conversation I wanted to have, which is, how can we as prosecutors better understand and really take the time to realize that we should understand, okay, what is your role as victim witness counselor? What are the boundaries? What can you do? What can't you do? And then are there confidentiality issues with that, and all of those things? So I've come up with a couple of questions that I looked back and reflected upon and thought, I should have been asking these questions as I was working to figure out whose role everything was, and who I could then say to the victims that came into my, maybe came to my office for an interview, and something came up in the interview, and realized that there was some need or resource that I wanted to connect them with, who I should be going to do that.
I had some of those same challenges as a young prosecutor, especially when there'd be folks from different agencies, and there'd be someone from the DV shelter that would show up at a hearing. And then I know we had these victim witness professionals in our office, and what's their role. And then we had other folks, and I'll speak for myself, and maybe other people have been in this boat. The mistake I made as a young prosecutor is, if I ask questions, are people going to realize I'm faking this? And so there could be a reluctance to sort of—
Not just you, Jonathan, not just you.
Not just me. Okay. So I thought that would be just me. And because I really described an imposter syndrome. If people figure out I don't know this, or if I don't figure it out for myself, I'm going to be I'm going to get fired, or something of that nature, or made fun of, whichever's worse. I'm not sure. And as a young prosecutor, a lot of these systems that we have and that have evolved, they're not intuitive, and they're not something really easy to understand. And you don't have to take the 1 to 2, 3 years or whatever to figure out all these relationships. You can sort of speed it up with questions like these that Jane have asked. Probably the biggest difference and the biggest thing we want to learn is the advocate, or this professional working with the system, are they system-based or community-based? And because that's going to be a big difference in their purpose for the victim. Now, really, what's the big distinction, or how do you distinguish between system-based or community-based? Is ultimately someone who's going to be system-based on some level is working for the government. Their check at the end of the day is paid for by the government, maybe a law enforcement agency, maybe a prosecutor's office. And at the end of the day, they have the same obligation to broader goals of justice as a police agency, law enforcement agency, and as a prosecutor, which means if there's things that are exculpatory that are understood, that system-based advocate can't protect the victim. A community-based advocate is going to be in a different bucket. And system-based and community-based, they should complement each other, because they can help one another, and they help meet a victim's needs in different ways. But the community-based, in not being part of the system, they are there solely and entirely for the victims, whatever the victim's interest is. And they can protect that victim, including in a lot of jurisdictions, having statutes that have confidentiality protections for communications that a victim might make with someone who's in a community-based organization, privacy expectations, and things like that.
Let me ask you, because
Sure.
before you go on, I think this gets a little bit fuzzy sometimes if you're working in a task force, or I worked in a specialty courthouse where there were advocates that were working for the court. So if you came in, got a protection order, there was somebody there to help you. And I don't think I really understood where that paid, who was paying that person in that courthouse.
Sure, and I think the model might be a little bit different in each courthouse in each community too, and so that's why asking these questions to the people you encounter are going to be so helpful, because you're going to be figuring out how this has evolved, particularly or specifically to your community. But really, I think maybe someone who's going to be a victim support personnel or advocate, such as circumstance you're talking about when a victim files for protection order, they're going to be there to help the victim navigate the system. And that's not exclusive of what a community advocate can do, but sometimes a community advocate may be providing more direct services to a victim or connecting this victim with a broader array of services rather than just services a victim needs to get through and understand the system, whether it's accompaniment at court hearings, whether it's figuring out what kind of restitution is owed, whether it might be childcare needs when they are showing up for court. These are things community advocates can do, but these are often going to be, and I don't want to say categorically, but these are things system-based advocates are going to be more designed to do.
Got it.
And then also, I think it depends a lot on your community. Now, I know you worked in a really metropolitan area, Dade County and Miami. Some like a rural community that might not be as, well, if I characterize Miami as vigorously resourced, you might give me a raised eyebrow. But compared to maybe a very rural community, comparatively, Miami is very resourced. So there is a chance or opportunity for a lot more specialization, including in the array of advocacy resources that's available to a victim. A more rural jurisdiction might have advocates wearing a bunch of hats. Maybe there isn't connection to a community-based advocate, or maybe there is only a community-based advocate that's going to be doing a lot of the things a system-based advocate traditionally does, which is why I mean, in my view, I think a lot of times, while there can be broad similarities, the specifics are going to be really individualized across the country.
Yeah, and I think that brings up a great point about how specialized you have victim services, because in a large community like Miami, we were privileged to have community-based advocacy that kind of fit different communities. So you might have an advocacy organization that was serving our LGBTQ plus community or our Haitian community. And so you would have what we would call like by and for organizations that were run by and for a specific community, or had a different capacity as far as serving those with disabilities. But you might also just have, one service provider in your area. So good to know about that. If you have the opportunity to work with by and for organizations or more specialized organizations, that can really be helpful to victims and survivors. I know that the work that I've recently been doing as part of our survivor led initiative called Just Exits, that's something that they really talk about as survivors, and peer-led organizations were really helpful for them. So great to kind of think about, what does my community support, and is there an opportunity to maybe build some capacity in those regards as well?
And when you're talking about this too, it reminds me, no one has to be an island. No organization has to necessarily be an island. And maybe if you're from a community doesn't have the scale or experience in dealing with marginalized populations, somewhere, even if it's a 4-hour drive from you, but maybe just a phone call away, there's going to be some sort of area that's going to have advocacy services and organizations that do work with those kinds of specialized populations. And they might not be able to drive out the 4 or 5 hours to help you in with your particular victim or client, but you can certainly reach out to those organizations to start maybe appreciating, gee, help me know what I don't know. So I can help this victim better. And gee, maybe it won't be as specialized or as particularized as if that victim was in a community with a specialized agency, but you can certainly improve your services that are available for that person as best you can.
And that's actually one of the benefits I know we've noticed with COVID. I don't know if one of the benefits, but as a happy outcome of COVID is this realization that victim services, well, maybe not the perfect scenario, but connecting with services via Zoom and all of this technology that we now have can actually maybe build that bridge of the 4-hour drive, and they could perhaps do some services around a Zoom or any other kind of sort of networking program.
Well, that's a trade-off, isn't it? And I know with our colleague Patty Powers, we did a lot of training during the pandemic and starting to learn from the different ways jurisdictions were handling remote, doing everything remotely. And the big fear was there'd be no advantages to doing anything remote. And with practice, it's recognized that while not perfect and not a global solution, remote applications can make things a lot better for victims, and that you don't have to figure out childcare issues to get services. You don't have to worry about parking costs or driving costs or public transportation costs. You don't have to worry about rescheduling your shift or employment issues, as it does give a lot more flexibility. Now, I'm not suggesting everything should be globally virtual when we're providing services to the victim. Hopefully we have a hybrid of both of them. But it's not all bad, and it can certainly broaden one's quiver of how you're able to give individualized services to victims, like you were discussing. Yeah.
So the last couple of questions here I have, again, based on my own sort of ignorance, and I love that you named that imposter syndrome, because I feel like that really held me back from better understanding how I could collaborate with victim services. So hopefully those out there listening learn from that. But I really miss this piece of some victim service professionals are providing direct services. They're providing counseling, they're providing legal services, they're providing medical care. But a lot of the folks that we're working with, their roles can look more like case management, or their role is to make referrals out. Like our victim witness counselors that we had on staff at the prosecutor's office, their job was to let everyone know about upcoming court dates, maybe help them apply for victim compensation that they were eligible for, but they weren't necessarily providing direct services to the victims. And I think that was a piece that I missed early on in my career.
That's something I could have trouble appreciating too. And especially, I think there can be an attitude I've seen with some prosecutors of, rather than working with victim service professionals, it's more an attitude of, okay, you handle this victim stuff while I do the other stuff. And that's not really good for either party. I think trying to figure out some sort of approach where you can work with victim service professionals is going to help you better understand those differences and better serve victims too. So you're able to understand and talk to victims about, hey, gee, rather than sending you over down the hall to this office or down the street to that advocacy, what do you need? Oh, gee, I know someone who can help you. Let's get them on the phone together and talk. Hey, I've got my victim, Jane Smith here. Do you know anyone that can help her, or how can we connect her? Can we do that together? And this is just a sort of very sort of abstract example I'm giving. I should probably illustrate it better than I am.
Well, first off,
but most
Jane
people want to
Smith is
help
very
others.
close to Jane Anderson, Jonathan Kurland.
That had occurred to me. I should have figured out another pseudonym. You can tell how well we rehearse this before every.
Yeah, lots of practice. so yeah, the last thing that I had on here was, again, I think it informed by the work that we've been doing more recently, more intentionally bringing in those with lived experience survivors into the work that we're doing at AEquitas, but also I know that victim service organizations have been doing that for a lot longer. And so it's really interesting also to make sure we're working with folks that are informing their practice by those with that lived experience. So whether that is your office employs folks that have that lived experience in those positions, or organizations that are employing or being led by those with lived experience, we know that that can really make a difference in how services are provided and how they're received.
I would note though, too, that we do, I mean, working with people and listening to people who have lived experiences is critical. But we don't want to put on the burden of one victim of being the spokesperson for all victims. And so it's important to recognize that, nor do we want to necessarily, because we're listening to the folks with lived experience, tuning out what the actual victim in front of us says they need, because each of these victims are going to be individuals, and how they respond and what their needs are going to be individualized. Folks with those lived experiences, that can be critical for helping us to see where we might be short. But it doesn't absolve us of paying paying attention to each victim individually.
Yeah, that's important. Okay, so now let's we know who they are now, the variety that we have, and the different roles and responsibilities. But how does it work with prosecution? What do you think this collaboration really brings to our work?
Well, that's a great question. These are a great answer about some of the ways that they can maximize our ability to help and work with victims. In the sense like, hey, look, some victims, depending where they're coming from, their trust or comfort or rapport with us as prosecutors might not be where we would like it to be. The right victim service professional can help bridge that gap, especially if we have not just a working relationship with our victim service professionals, but a relationship with them. In other words, if we have relationships with our victims that go beyond just the individual case, but more broadly is ongoing, we've got a great way, a trust level with this victim service professional to listen to them so we can open ourselves to what the victim needs and hopefully have a bridge to meet the victim, to understand, to help the victim understand what our limitations as prosecutors might be. And because sometimes victims, especially if they come from a background where they might not be trusting of law enforcement, or they have experiences where that distrust of law enforcement might be well placed or formulated by or informed by experience, we can think of ways working with victim service professionals to minimize that. And so, look,
these like that handoff that can happen, right? Where a victim service professional can say, "Hey, I've worked with Jane on other cases. She actually gets this. She understands." And then that trust that they've built kind of gets a little bit rubbed off on me.
Right, and exactly. One of the things I always think that you're making it as a prosecutor working in this area. When you have someone who's working for a victim service professional, when you have them on direct dial, or I suppose I should update it, because direct dial would be what I would say in my day of age, when you have an active text thread with them or something of that nature. So that you can contact them. Hey, look, I've got this victim who needs this help, or I'm having trouble reaching this victim. And then they're able to connect with this victim. And similarly, the victim service professional can reach out to you like, hey, look, I've got some difficulty. This victim isn't comfortable coming in. Can you help? When you have that active sort of relationship, and collaboration is what's going to be building that. A lot of times, I mean, folks can be frustrated at multidisciplinary team meetings or case review. It's like, oh, what's the point of them? Are we ever accomplishing anything, or is there anything? And I think often things can be accomplished, but probably one of the most important things of these meetings we go to is building up these relationships with people from other disciplines where we get that active text thread going so that we can contact them at 2 a.m. or 3 a.m. or they can contact us at that time. Or we can have them, for those who are using direct dial or speed dial, you can have them on speed dial.
Yeah, and I luckily did get to that point at one point in my career. And what was even more helpful than that facilitating communication, sometimes like I've lost track of somebody, that was always amazing. But also I'd have these things pop up in my cases, maybe these weird, like a fact or a victim behavior that I couldn't quite put together on my own. And I'd be able to say, like, hypothetically, what if a victim did this? And then they were able to say, oh, that's super common. That's actually probably because of X, Y, and Z. And so they were served as, not a formal expert witness that we're going to talk about in another one of these conversations about, who we can bring in to actually serve as a testifying expert witness. But they sort of served as my own personal expert when I was making charging decisions, when I was formulating trial strategy and pretrial motions of what I wanted to put in and bring out, and how I was going to deal with maybe some of those facts that I thought a jury might struggle with as well. They were great on that regard.
A consulting expert.
That's it. That's what we call them. Not my own personal expert. Okay, a consulting expert that I probably should have paid and didn't. But they're also really great at, getting the services, figuring out the safety plan, and sometimes identifying, maybe not identifying directly witness intimidation, but giving me a heads up. Like, hey, so-and-so has missed a couple of appointments after, kind of being really responsive. And then I would be like, wonder what's going on. And maybe pull some jail phone calls if it was a case of sexual violence where the victim and the offender knew one another, or was an intimate partner sexual assault case, more than most. They could sort of give me that first indication that, hey, you should be looking, something might be going wrong.
Helps you get something on the radar.
Yeah, exactly. Okay, but it is not always just smooth sailing. And because no, not always. Because we do have different roles and responsibilities. And I think, especially when we're working with community-based advocates or victim services, they provide such a great benefit to victims. And you articulated that early, or like they're just there for the victim. And they often have these confidential relationships that can sometimes turn its head and serve as a tension point if maybe we're trying to locate a victim and we think, okay, we're trying to make sure somebody's safe. Why won't you just tell me where they are? Or why won't you tell me what they last told you? And that can kind of become a tension point. So this idea of confidentiality, how do we work through that?
Well, it can be difficult, and confidentiality can work both ways too, or sort of sometimes tensions with that, depending how it plays out in the individual community. As you were saying, certainly the prosecutor can be frustrated, and maybe law enforcement too, with the community advocate's responsibility to ultimately be the victim's advocate, not exclusive of anything else. And part of that is going to be a lot of times statutory expectations about confidentiality protections, so that victim can have that 100% trust in the community advocate, and that they can be supported no matter what. From a law enforcement perspective, what can sometimes frustrate community advocates is law enforcement and prosecutors might necessarily want to be protective of information in an open investigation. There might be things that they don't feel positioned to share with the community advocate. There might be some things such as sealing orders with search warrants or wiretap applications, where by law enforcement or prosecutors can't share with community advocates about something that's developing in an investigation. Maybe something going on with grand jury. Now look, ultimately, I think rather than bemoan these confidentiality or privacy expectations between disciplines, a lot can be resolved just by understanding the reasons for each of them. And a lot of that is going to be facilitated by a relationship between disciplines. The better law enforcement and prosecutors understand the purpose serving the confidentiality protections community advocates have with victims, I think the more that they can work with that. I was going to say work around it, but work with it is a better way to put it. Similarly, the more community advocates are going to be understanding not just the legal requirements, but the legal reasoning why things like grand jury proceedings are secretive, or maybe specific like wiretap applications in some jurisdictions or search warrants, why that happens for the betterment of the public as a whole and to protect. I think the more community advocates are going to be able to maybe explain these dynamics and issues to a victim when a prosecutor might not be able to. Look, it's not going to be perfect. And I think a lot of this understanding is going to be born through trial and error rather than just magically appearing. I think at the end of the day, when probably appreciation is achieved, it results in an MOU. And a lot of times, though, that memorandum of understanding isn't going to be necessary because everyone intuitively understands it by that point anyway. But nevertheless, there's a memorialization of it.
I was working recently with a multidisciplinary team that was just getting started, and we were in a big room, and we just asked the question of each sort of group, like, what is one thing that you think is commonly misunderstood about your role, or what is one thing you wish other people understood better about your responsibilities? And the conversations that came out of that, like, little round table were so important, because we literally had law enforcement going, oh, I had no idea. And then I had, and vice versa. And it was often around these kinds of tension points about, what is my ethical responsibility for charging? That was something that came up a lot. It was like, okay, well, this person's arrested, but now you're making a charging decision to not charge, or to charge different crimes. And so the conversations about the difference between probable cause and beyond a reasonable doubt, and things that we think people just know, especially if they're working with us already and they're in the system, we think, okay, they get this, but it isn't always intuitive. And I don't think, most victim service professionals get like a, Miami State Attorney's Office policies and procedures guidebook,
Right.
that we had. Same with like discovery, and the responsibilities we have to provide certain things in discovery, but then also our ability to maybe litigate pre-trial what comes before the jury, and that those are two different things as well.
But, and I also think too, though, by having to explain, whether you're an advocate or a prosecutor, by having to explain why you do something, it helps gives you a better understanding of why you're doing something. So it's not, well, that's how it's done, which isn't a great defense of a practice, because that's how it's done. By having to actually explain to someone else why it happens, you get a better appreciation. Like, you might get pushback from a community advocate about a charging decision. Why don't you charge on this? Well, yeah, we do have probable cause, but we charge to have a higher than probable cause, which a prosecutor's office might decide. But then a prosecutor's office should be asking itself, well, gee, are we having one standard for this type of case for charging, but another for that type of case? That kind of challenge on our charging decision, hopefully it's going to be uniform no matter what kind of crime it is. But getting pushback on that is really going to sort of give you a chance to sort of take that inventory that you might not otherwise have occasion to as well.
I love that point. Somebody once told me that the biggest test of whether you know a subject or not is whether you can teach it or explain it simply to somebody else. So that idea of us having to talk to victim advocates and service providers about what we do, it forces us to sort of say, okay, do I really get this? Am I really doing this in line with some standard procedure or standard filing decision? And we know that sexual assault cases in particular, and that's what we're talking about here, that there are a lot of places where, charging is infrequent for
Mhm.
lots of reasons. And, this is why we're having this particular series. Um, and, somehow are we putting up a higher standard because maybe we're gun shy about these kinds of cases? We haven't had success on alcohol facilitated cases. So now we're requiring this much higher burden to charge those cases instead of reflecting on our own practices and maybe trying to improve how we go forward with these cases.
Yeah, no, that's a great point. And look, as attorneys, we shouldn't be scared of an adversarial process, because an adversarial process is an ends in of itself. By having an adversarial process, we get stronger cases, stronger arguments, we get closer to the truth. So
Yep.
being challenged on something isn't bad. It's good. We're asked, even if we think the question is simple, like, oh, well, wait, let's take stock.
Mm-hmm. Mm-hmm. So this is, we've talked about all the ways that victim services can help us serve the victims who we are serving in our cases, but how can we assist them? I don't want them to think it's all given, no, that they're just giving, and we're just taking. What can we give and what can we provide to victim service professionals in this relationship really that we want to build?
Well, I don't know that there is a global way. I mean, I know some of the practices I would like to try to do to just that I think maintained good relationships with victim service professionals is update them on the case about what's happening. Hey, I don't know if you knew that, but we're going to have a pretrial hearing on such and such a date. Hey, trial is going to be on such and such a date. Want to let you know we are hoping to call the victim on that date. Hey, we got a sentence. You did a lot of work with the victim. Want to let you know that what the judge sentenced the defendant to was, A, B, or C. Or if you really, and look, for bigger offices where folks forget what happens after trial, hey, the appeal came back. Here's a copy of the judge's decision. You can read what happened. Or, I mean, I did a lot of appellate work. Or, hey, we got the federal habeas hearing. We're going to federal court the other day. Here's a different ineffective, et cetera. Sort of just, and depending on the case, but keeping them looped in on the communication, I think is a minimum of what you can do. And it really is so easy these days with email, just to hit copy on a send or just a quick note to someone. Or if you've got these text threads with them, you can also give them a heads up that way. And that's it. We talk about prosecutors assisting victim service professionals, but really sort of promoting the interdisciplinary collaboration. That's a good thing to be doing with your cops too.
Yeah.
Like involve them, the things that your discipline is focusing on, when you can, involve the other folks who've been working with the victim on that same kind of case and what's happening, and
Absolutely.
keep them in the loop.
And what I always find remarkable is we'll do these trainings. Jonathan, I know you can back me up. We'll do a training and we're coming in and we're giving sort of prosecutor focused training, and the audience is multidisciplinary. And the victim service folks in the room are always just eating up the information about how prosecution works. Whether that's because, everybody loves true crime or something, but I think more so it's because it helps them help their clients. The better they understand the system and what we're doing, they can better assist their clients. And so multidisciplinary trainings where everybody in the room's hearing the same thing. If a particular emerging issue is coming up, like involving your partners in decision making, if you're coming up with like a new form or a new way that you're going to notify people, like involve them in those decisions as well, and really empower them to say, like, one thing I'm thinking about is we just blindly sent notifications for trials all the time in Miami. And it was to keep everybody informed about what was going on, but it ended up being a lot of these notices coming in the mail that were then spiking anxiety with victims. And they were certainly notifications of things that we knew weren't going to happen, or they were for hearings that, were scheduling hearings or things like that. And so we were needlessly, sort of piquing the anxiety of some of the victims we were working with. And so trying to think about, okay, can we keep everyone informed in a way that is maybe not putting something in their mailbox every other week, when we know that, the trial's not going to happen until, a year out or something like that. And victim service providers could really help with that and say, hey, this is what we hear from clients of, what they need, and they're all going online anyway and looking at these dates or whatnot. So that was helpful too. And that was just a simple like policy decision that we could involve victim service professionals in.
And your comments had me sort of reflecting. I can remember hundreds, if not thousands, of conversations I've had with victims about the trade-offs of going to trial versus taking a plea that was on the table or a negotiated plea, and about trying to inform them so I could get their informed input. And so many times, and these sort of trade-offs, they're not intuitive, especially to someone who's not in the system, whatever they might be involved with. Over the course of these different meetings, having the same victim advocates present at these meetings, especially when you're not trying to sell the victim on something, but you're actually trying to do your duty of informing the victim rather than selling them on something. But when you're honestly and ethically and professionally informing the victim about what, in your professional judgment, the trade-offs involved are, and giving that victim input, the victim advocates or community advocates that get to listen to those meetings over and over, they have a better understanding too. And that's something that they can talk about with victims, maybe when you're not around, and help them appreciate and understand.
Yep, absolutely. Okay, well, this has been a great conversation, and I think we've sort of hit some of these going forward action items, which is really to think about where are additional opportunities where we can enhance collaboration. How can we start building that relationship, that trusted relationship between prosecution and our victim service professionals, because that communication being so key, that text thread that ends up just being incredibly helpful if we can get to that level of trust and respect and professionalism. And then leveraging those relationships, not just to, improve our case, but really to enhance victim safety, to enhance their ability to participate with us, and really overall enhance the work that we're doing. So we've got a couple additional resources we wanted to point you guys to, talking about, victim advocates being present during sexual assault exams. We've got a summary of state laws available to you. We also have some additional references about medical evidence and the role of a SANE, talked about the medical professionals as being key victim service providers, and then just another resource that talks about how to build and how to benefit from a coordinated community response, or CCR, to sexual violence. So I'll let you pitch our office hours, Jonathan. I know you're really involved in these and they're great, before we say goodbye.
Thank you, Jane. So our office hours are held third Thursday of every month, 2 to 4 p.m. Eastern. And the reason why we choose that time is we hope it's the most convenient time across this country's numerous time zones. And what we try to do during this office hours is we give a chance for prosecutors from across the nation to join together and just discuss issues or challenges that are being faced in your office. Now, I like to specify these aren't a webinar. So if you're just ready there to passively receive information, office hours probably isn't as what you're looking for. But if you're looking to have a conversation with other prosecutors, collaborate, network about challenges they're facing, this can be a great opportunity. I kind of liken it to that when it works, it's sort of like that good lunchroom or break room conversation you're having with other prosecutors after you get back from court about some challenge you have, where everyone sort of brainstorms together about ways around it. Now we come ready each month with a topic that we hope is topical and of interest to people. But really the forum is open to whatever people want to discuss. So you see where you can register for these trainings. We hope to see you there on a regular basis.
Thanks. And this is our contact information. Always feel free to reach out, especially if you've got one of those cases or questions you're working on specifically. We're happy to do some research for you or to be that soundboard for you. And Jonathan. So thank you so much, Jonathan. And we'll talk to you later.
Bye-bye.